Professor Marianne from our hen house, her knowledge overflows. Legislation from cat to pig to mouse, she knows all of those. Critter defenders from across the globe share their stories first to last. So welcome to what we now know as the Animal Law Podcast. It's the Animal Law Podcast.
Welcome to episode 9 of the Animal Law Podcast. Here we are, and we have a great show for you today because Eric Glitzenstein is going to be joining us. And Eric is one of the smartest lawyers I've ever met, so get ready for quite a ride. I'm sure you'll learn a lot from listening to him. He's really an environmental lawyer, and we'll be talking a bit about environmental law and animal law and when they match up and when they collide. And we'll be talking about a specific case of his that has to do with eagles. And I'm not going to make any remarks about legal eagles. None. Zero. Before we talk to Eric, though, I want to talk a little bit about PETA's lawsuit against Whole Foods, which we talked with Jared Goodman about. Jared is a lawyer with PETA and a former student of mine. And we talked to him about it a while back, and it has since been dismissed, which is unfortunate. And I was sorry to hear that. Consumer protection law. It was a consumer protection suit about some of Whole Foods advertising about their quote unquote humane meats, and their 5-step program. And PETA had some strong disagreements about the accuracy of their advertising. And, consumer protection law is a really important part of animal law because, as we all know, the laws protecting animals, especially farm animals, but animals in general, are not very strong and they're hard to enforce. The laws protecting consumers are a little better, though they're still challenging to enforce. And the cases can be very difficult to win, and PETA has run into some roadblocks here with its suit against Whole Foods. I understand that they are planning to refile, so that's good news. The court had issues with whether the evidence that they had brought to bear was specific enough or extensive enough or clearly identified sufficiently regarding their proof of reliance. They have to prove that their plaintiff actually relied on this false advertising in buying the product. And PETA had relied on a California Supreme Court case, in Ray Tobacco 2 cases, that you don't have to actually prove individual reliance on a specific false statement, which is really hard to do in a lot of cases. They wanted to show that the ads were part of a long-running ad campaign, which of course they certainly were, and that the plaintiff relied on the cumulative message. And I think there's a very strong argument for that. We all know that Whole Foods gives everyone the impression that their 5-step program is protecting people from buying inhumane products. And there's strong evidence that, that's not necessarily true. But anyway, it's unfortunate. The case was dismissed. And we will see what happens. And it'll be something to keep an eye on. Of course, an interesting factor about this case is that the Humane Society of the United States was really pissed off about PETA bringing this lawsuit. Wayne Pacelli wrote a blog about it. Wayne Pacelli is connected to Global Animal Partnership. He's on the board, I think, which is the organization that used to be part of Whole Foods, but since it dissociated itself and is the organization that does the ratings and the evaluation of these quote-unquote humane farms. And, I'm not an HSUS hater by any means. I think they do remarkable work. And I understand that they occupy a very different position in the animal protection movement than PETA does and than I do. And I really, really admire a great many people there, and I admire the work they do. However, unlike Wayne, I would really like to see this suit go forward. We know that none of it's humane, not according to our standards of what humane is. And that's obvious, and we all know that. But it's clear that some things are less horrible than others, and some animals are raised for food in ways that are less horrible than others. And that's just the world that we live in. And that's the world that we live in, is the world where these lawsuits have to take place. And the question, I guess, is whether it's really possible to make it sufficiently not horrible that they can afford to tell the truth. And what Peter was saying is that no, that it's not. Peter wasn't saying that this is perfect, that they're claiming that it's perfect and it's not perfect. They're saying it's not what they say it is. They're saying it's one thing, and they're saying it's humane, and it's not. It's deceptive. And it would be nice to see those allegations tested and really figure out exactly where it is they fall. Because, especially if you follow the work of James McWilliams, he's such an insightful commentator on animal protection, and his recent book, The Modern Savage, really goes into these issues in depth. The question is like, what can this word humane be, and is it ever possible to get anywhere near what anybody thinks is humane? It's not possible to get near to what I think is humane, because I don't think it's humane to do any of it. But is deception actually necessary for these firms? Because it's just simply impossible for them to economically produce products, even though they're charging a huge premium for them. Is it still impossible for them to economically produce their meat products while treating animals by anybody's definition of humane? And, Peter was kind of saying that Whole Foods is not pulling this off. And I would love to have seen those questions get to court. So these are the questions that could be answered by such a lawsuit. What's really happening to animals? We have more info than we used to have, but we don't really know, and it's nice to get those questions into court. What's really happening? Not what are they telling us, not what do the standards say. What's really happening? And what do those standards say, and do those situations match? And the second question is what do people really mean when they use the word humane? They have no idea what they mean, and that's why it's really important to look at these standards and say, is this what I mean when I say humane? Because they're not very high. They're not meeting them, and even if they met them, they're not very high. It's such important information for all of us, and it's so important for this stuff to get into the courts, where there can be, instead of just animal rights activists yelling and the meat industry yelling and everybody ignoring both of them, that gets into court and somebody has to actually look at the facts and make a decision. And it's a shame to see these cases not getting into court. Well, anyway, a case that did get into court, it has to do with eagles and the wind industry, and it's a fascinating case, and it's a fascinating topic, and it involves statutes that we should all know about, and too many animal lawyers are not sufficiently proficient in environmental law, and that's one of the reasons I'm so excited to welcome Eric Glitzenstein to the podcast. Eric is a founding partner of Meyer, Glitzenstein, and Eubanks, which is in Washington, D.C. He specializes in environmental, wildlife, animal protection, natural resource, open government, and other public interest cases. In fact, he's one of the leading lawyers in the country in these areas. Among the animals he has represented are Canada lynx, manatees, grizzly bears, whales, and many, many others. Welcome to the Animal Law Podcast, Eric.
Hello, and good to be here.
I'm so happy to have you here, and I'm so excited to be talking about some issues that I am not as familiar with as I wish I were. There are a lot of crossovers between environmental law and animal law, but some of us are not as familiar with the environmental statutes as we wish we were, and so I'm happy to be able to ask questions. It's a great thing about doing the Animal Law Podcast is I get to ask questions. It's so much easier than answering them. And before we talk about this specific case, which you have recently had quite a bit of success with, let's talk a little bit about NEPA, the National Environmental Policy Act. And while many people have heard of of environmental impact statements, they might not know about the actual statute, even though it is an extraordinarily important statute. It really may be more important than any of the environmental statutes I've heard some people posit. Can you give us a summary of what NEPA is and what it does?
Sure, and you're absolutely right. It is an extremely important statute, and it's particularly important, I think, to people who are looking for opportunities to protect animals, because it imposes obligations very broadly on all federal agencies to, in effect, look before they leap, is the concept underlying the statute. It is a purely procedural statute in the sense that it does not impose any ultimate substantive obligations on agencies, meaning that once the agencies have engaged in an analysis of the impacts of their actions and alternatives to those actions, it's very clearly established that the law does not prevent the agency from making even a very bad decision from a wildlife protection or some other environmental standpoint. But nonetheless, the obligation to engage in what the courts refer to as a hard look at environmental impacts, and many of the cases we're concerned with and the one we're talking about today obviously involve wildlife impacts, and also to consider seriously whether there are alternatives that could avoid those impacts or reduce those impacts in some fashion, is a very valuable tool. It's a valuable tool both from the standpoint of actually requiring agencies to seriously scrutinize what they're doing and what the implications of what they're doing might be. But it's also very important because it affords an opportunity for judicial review of whether the agencies have actually undertaken that level of analysis. And oftentimes, courts play a very important role in sending agencies back to the drawing board and to take a much harder look than they otherwise would. And the statute was really sort of born out of an understanding that many things agencies do when they're carrying out what they view as their sort of prime functions can have collateral consequences on wildlife or other environmental interests, and that frequently agencies will be preoccupied in a very sort of bureaucratic way with pursuing their mission and won't necessarily think about these other consequences. So the whole point of the statute was to basically embody in one place this understanding that we really do want agencies to take this hard look at what they're doing, what impacts it has, and hopefully to take that into consideration when they make a final decision, which could be going forward, scrapping whatever it is they're thinking about, or, as was often the case, at least taking some steps to address the problems that are identified and minimize the impacts. Again, much of what we're concerned about is wildlife, but obviously it can go broader than that. So that's really the concept behind the statute passed in 1969 as part of really what were, in many ways, the golden age of federal conservation laws that we have in this country, and it's really one of the cornerstones of federal conservation policy.
It is amazing how successful. I mean, I know when it was passed, there was a lot of speculation that it was worthless, and it's been an amazingly successful statute. Just forcing agencies to actually really, really do their job has been, and take this hard look instead of glossing over things, has been very successful. Can you explain to us briefly just exactly what environmental impact statements are, and also what is the preliminary step? Environmental, I know they're EAs. What are they? What does that stand for?
Yes. So that stands for environmental assessments, and there's really three levels of potential review. The environmental impact statement is the broadest and most comprehensive, and that's required when you have, as the statute refers to it, a major federal action significantly affecting the quality of the environment. So when an agency embarks on an action, and this could not just be the action of the agency itself, could also come into play any time an agency is funding a third party to engage in an action or otherwise authorizing an action carried out by someone else. So it really sort of broadly applies to federal actions and federally involved actions.
But it can also involve actions that private parties is taking if they have to get some kind of permit.
If they need a permit, if they need a license, if they even need federal money. So many, local transportation projects or permits from federal agencies to take wildlife, any of those kinds of things can implicate NEPA. And so you have the EIS, which is the broadest document, and it's really the one that those of us who are pushing for full NEPA compliance are usually trying to get agencies to do, because those are the most comprehensive analyses. They're the ones that have the most public process, public comment. Hearings are generally required when you do an EIS. The statute, and actually one of the things that's important for people to understand is the statute is a fairly broad, written in very lofty terms without a lot of detail. Many of the details have been fleshed out in regulations that were issued quite a few years ago by a White House entity called the Council on Environmental Quality. And those regulations are really extraordinarily important for anybody who's thinking about bringing a NEPA case because they really put a lot of detail into what's otherwise a rather broad and somewhat amorphous process. And the regulations provide that agencies, when they're uncertain whether to prepare an environmental impact statement, can prepare the somewhat reduced document called an environmental assessment, which can then be used to evaluate whether the project is significantly impactful of the environment to require some resource to require a full EIS. And even if it doesn't, the EA, which is the acronym which is used, itself can afford some level of analysis as well as some consideration of alternatives. And then the third and most cursory review, it's actually not even a review at all, is what's called the categorical exclusion. And that's when an agency has determined in some sort of a regulation that a particular kind of activity categorically will not have an impact on the environment. So, if some agency is hypothetically has a program or a project for, procuring pencils, and we've decided that activity will never have an impact on the environment, then we can sort of decide that falls into some categorical exclusion. And those are really supposed to be reserved for situations where we know that category, from experience and from common sense, simply never rises to the level of having an impact that requires a fuller analysis. But even for when you invoke those kinds of exclusions, you also always, under the regulations, have to provide for what are called extraordinary circumstances in which a normally excluded action would require some fuller analysis in an EIS or an EA. But those are the three sort of overall levels of review for every federal agency action that would otherwise have to be analyzed in some way under NEPA.
So we've got the basics on the statute, and let's get into what was going on here with that background. Let's talk about what ultimately caused your lawsuit. How were eagles put at risk? What were the facts of what was going out there in the real world that were putting eagles at risk?
So the background of this case, there's actually sort of a broader context, which I'll just touch on for a bit, and then maybe we can get back into that, and then a more specific context for this regulation we were challenging here as violating NEPA. The broader context is, as everybody knows, we are trying to make, and by we I mean sort of generally as a society, trying to address the serious climate change problem for those of us, and I count myself among those who believe that climate change is real, and we need to make a transition away from fossil fuels to renewable forms of energy that can ultimately wean us off of those sources, which are themselves bad for many reasons, but not least of which is because they ultimately will be horrible for wildlife. Many species, individual animals as well as species, will suffer tremendously from climate change if we don't do something about that problem. So there's certainly no doubt that we need to do that. The question that our firm and others have been looking at for a number of years is how do we make that transition in a way which takes into account what could otherwise be very serious impacts on wildlife and various species that are potentially affected. And wind power has been one of the ones that has raised this issue in a very, I think, important way. Because nobody again doubts that wind power, if properly built and pursued, can be one of the renewable energy sources that helps us make this transition. If wind power is built in the wrong places, if it's built in the wrong way, and most importantly, if it's built in a way that doesn't even acknowledge potential wildlife effects, it could have a really devastating impact on a number of different animals. And the principal ones that we've looked at have been bats and birds. And I won't get that much into bats unless we want to touch on it a little bit later. But bats have really been hit hard by improperly sited wind power projects. And birds are the kinds of animals that we've looked at for this project and some others. And many species of migratory birds can be really harmed tremendously by projects that are put in wrong places, that are put in migratory pathways, that are put near nesting sites. And one of the particular kinds of birds that are being affected are eagles, as well as other raptors, but the ones that we're focusing on in this particular case are eagles. And we're talking about bald eagles, which I'm sure most people are familiar with bald eagles as a symbol of the country and having other kinds of cultural resonance, as well as being just magnificent creatures in their own right, and golden eagles, somewhat lesser known species, but another extraordinarily majestic species for people who have seen those in the wild or seen photos of them. And they're actually both subject to a special law called the Bald and Golden Eagle Protection Act, sometimes referred to as BGEPA, if we want to use the acronym. And it's, since we love acronyms in the law, of
we
course,
really do.
it's sad, but we do love those acronyms. And that's a statute, in recognition of sort of almost the special place that eagles have in American society. It's a statute which was passed specifically to protect bald and golden eagles. It's a very broadly written statute. It prohibits killing and other forms of quote-unquote take of eagles without appropriate authorization from the Fish and Wildlife Service, which is the federal agency within the Interior Department which administers that statute, as well as most of the other major federal conservation laws. What's really brought our case to the to people's scrutiny was the desire by the wind power industry to build wind power projects in many places which also happen to be important eagle habitat, actually habitat of other migratory bird species as well, but specifically habitat used by eagles. And one of the unfortunate realities of wind power is that frequently the place where companies want to build wind power projects because of their wind resources also happen to be places which are relied upon by birds that, of course, also use wind resources to do what they do, particularly winds that help them to minimize the amount of energy they have to expend on these very long migratory treks that they engage in.
So eagles have recovered somewhat from the time when I was a kid, when bald eagles were close to disappearing. And in 2009, I understand there were actually regulations issued that authorized some kind of take of bald and golden eagles. Am I right about that? And if so, can you explain what a take is?
Sure. And what I would say is, in terms of eagles recovering, bald eagles are considered to be in many ways a American conservation success story. One of the huge impacts on bald eagles was DDT, as people may remember, but also habitat impacts. And bald eagles, in many places, really have recovered, and so much so that they were originally protected under the Endangered Species Act, and then a number of years ago they were removed from Endangered Species Act listing, although, again, they still remain protected by this Bald and Golden Eagle Protection Act. Golden eagles have never been listed as a endangered or threatened species, but in many ways people are becoming much more concerned about golden eagles. There's a lot of evidence that golden eagle populations may be on the decline, and they actually appear to be perhaps even more susceptible to wind power impacts for reasons that are still being studied in bald eagles. So that's sort of where we are, and one of the things we want to make sure is that obviously we have as few impacts on bald and golden eagles as possible, given the fact that we've devoted so many resources to protecting those species over the years. In terms of the permitting system, 2009 is when the Fish and Wildlife Service first established some general ground rules for what kinds of permits could be issued for this kind of take. And take is a very broad prohibition. It involves not only killing members of the eagle population, but also injuring or maiming members of an eagle population, as well as under the statute and the regulations, even disturbing eagles. So, and particularly disturbing eagles who have nests nearby. And this is actually one of the huge problems. Eagles are very sensitive when they're trying to nest and rear their young. They're very sensitive to human disturbance, which is nearby. And so there are very strong rules on how close you can be to an eagle nest without causing the adults to abandon the nest or be overly stressed in trying to rear young. So all those things are encompassed within take. It's a very broad protective provision. And in these 2009 regulations, the service said, yes, you can get a permit under some circumstances, but we really have to make sure that it's not harming the local eagle populations, and establish a very strong standard that ensured that there would not be activities that were really detrimental to the maintenance of local eagle populations, as well as regional and national eagle populations. And as part of that, and this really gets into what our case was about, very critically, they said because we know so little about some of the effects on eagles, particularly from things like wind power and other impacts, we're only going to let you get a permit for 5 years for these kinds of permits. And what we're talking about here, again, are these kinds of incidental takes, and broken down further to something they called programmatic take, which was an activity like a wind power project that is kind of recurrent and long-term in nature, not like a one-time thing where somebody goes in to do a particular thing one day, but really sort of an ongoing, activity like a wind power project. And they said, we're only going to let you get these permits for a 5-year period maximum because we know so little about what's going to affect eagles. New technologies are coming along that could help protect eagles. We really want to have a very protective process. And so in 2009, they established this 5-year limit for those kinds of permitted activities. But then only a few years later, and really at the behest of the wind power industry, although other industries might benefit from the rule change, but it really was the wind power industry which pushed this change. They came along and said, we're going to take what was a maximum 5-year term for this kind of take and increase it to as much as 30 years, a 6-fold increase in the total length of the permit, which many people who have observed eagle populations and impacts on them is extraordinarily risky because, again, there are so many things going on in the environment. There are so many things going on with eagle populations that to give somebody a 30-year permit term was viewed by many eagle experts and wildlife organizations as just an extraordinarily lengthy and overly lengthy term from the standpoint of protecting eagles.
So that would mean that for 30 years, nobody would have to take another look at what the wind industry was doing to make sure that eagles weren't being excessively harmed? Correct.
What they did was they said that instead of being a permit period for 5 years, which could then be renewed with a new permit decision every 5 years, there would be internal Fish and Wildlife Service reviews, which may or may not lead to any actual public review of whether the permit should be renewed. And one of the major concerns expressed by organizations was, well, Indian tribes who cared about this, even other federal officials, including many within the Fish and Wildlife Service, was that's nothing remotely close in protecting eagle populations than a requirement for a actual renewed permit decision, because who knows what the internal Fish and Wildlife Service people will come up with, and given the paucity of resources that frequently these agencies have. And as people may know, a lot of agencies, including the Fish and Wildlife Service, have really been underfunded for many years. There's no guarantee that they will even be able to have the money and the personnel to even engage in these kinds of purely internal reviews. So we are left with a situation where a permit could be issued for 30 years with almost no scrutiny during that period of time as to what's actually happening, what effect it's having, what's happening to eagle populations, whether nests are being abandoned. And if there's new technology that comes along that could actually make these projects much more protective, no obligation to actually even incorporate that in order to conserve eagles and avoid impacts that could otherwise be avoided. So there was great concern that this would actually be, a much less protective system.
How did Fish and Wildlife justify this really huge change in the regulations?
Well, they literally justified it by saying that it was something that was desired by the wind power industry. There really is. I'm not just it's not just a rhetorical characterization on my part. If you actually read the regulation, it's a rather extraordinary, explicit statement on the part of the Fish and Wildlife Service saying the reason we're doing this is because the wind power industry asked us to. Really just acknowledging that this is a favored industry, and therefore we're bending over backwards to accommodate their desire for long-term permits. And the wind industry's explanation for that is that we need to get financing, and we can't get financing for what's basically a somewhat fledgling industry, no pun intended, when we have these sort of risks hanging over our heads. And in order to basically tell funders that we have reduced these risks, we need long-term permits, and these beekeeper permits is one example of that. And so that really was the rationale. Now, at the same time, the service also said, well, we believe our internal reviews will be protective enough. We will promise to give information about eagle deaths and other impacts to the public, that the public will see what's going on. But the real, raison d'etre for this entire rule change was that this particular industry was asking for it. And many of us have said, that's just not a good enough reason to it, especially when you're basically putting out regulations under a statute whose focus is not protecting the wind power industry. The focus is on protecting eagles. And as important as it is to have a transition to renewable energy, we have to do it in a way which really takes into account wildlife concerns, and particularly where we have a law whose entire focus was making sure that we're not doing things which are detrimental to eagle populations and these species that we've regarded as very important for so many reasons. But to sort of add insult to injury, they not only made this rule change, which was itself a very dramatic rule change, as you've pointed out, a real substantial change in the way they were approaching the whole business of protecting eagles. But they did so with literally no review under NEPA. So it sort of goes back to what we were chatting about, at the outset, the whole purpose of which is at least to basically look at what the impacts of a change like this would be before you embark on a programmatic, revision like this one. And they did not do an EIS. They did not do an environmental assessment. Instead, they claimed that the entire rule change could be done without no NEPA compliance whatsoever because it was, quote unquote, categorically excluded from any NEPA review at all. And so that was really the major legal thrust of our challenge to what they did. We had many grave concerns with the wisdom of what they did and the overall legality of this under BGIPA. But the real focus that we had was on the insistence on doing all this without engaging in any NEPA compliance at all, which was something that we thought was quite astonishingly unlawful, and the judge ultimately agreed with that position.
So that was a long introduction, but we have finally arrived at your lawsuit. And what statute did you sue under, and who exactly did you sue? Did you sue Fish and Wildlife?
We did sue Fish and Wildlife Service because they were the ones who actually issued the regulation, as well as their parent department, the Interior Department. And we brought the case, basically had three claims. One was that this was a violation of NEPA because they didn't do any NEPA review at all. We also argued that it was a violation of BGIPA itself because it wasn't sufficiently protective of eagles. But we also signaled to the court quite explicitly that if you agree with us on our NEPA claim, you don't really need to address this other issue about whether or not they complied with BGIPA, because if they have to go back and do more extensive NEPA analysis, they may actually decide to scrap this approach entirely, or they could have some other change that would affect the protective scheme that they had put in place. And then we also had sort of a subsidiary issue on Endangered Species Act compliance, and our argument there was that if you are going to impact eagles, you're also going to impact other wildlife species, including endangered and threatened species that share the same habitat as eagles, but you haven't really looked at the impacts of basically expanding wind power projects in endangered and threatened species habitats as well. And so those are the three major arguments that we sort of brought to the court's attention, and we won on what was sort of our major argument, which was the NEPA claim that we had. The judge didn't reach the argument at all about whether they could do this major rule change under BGIPA itself, and we did not prevail on our ESA claim, and the judge said, which we had not had a chance to devote a huge amount of attention to, saying that there really wasn't that much information so far in the record about impacts on endangered and threatened species, which is not surprising because since they hadn't done any NEPA analysis, there was really not as much opportunity to incorporate that information into a record. But the judge basically agreed that this whole thing had to go back to the drawing board because there was no NEPA compliance, and on that basis, the judge, whose name is Judge Koh, K-O-H, in the Northern District of California, invalidated the regulation and basically said you can't issue these kinds of long-term permits until you at least have gone back and done some more extensive NEPA analysis.
Before we get to the details of the judge's reasoning, can you just talk about who your plaintiffs were and how they had standing?
Sure. So the plaintiffs consisted of a number of individual eagle lovers. The lead named plaintiff was a woman named Deborah Shearwater, who lives in California and goes and looks for eagles on a regular basis, has places she goes to all the time to look for eagles, has seen bald and golden eagles routinely over the course of many years. And we had other individual plaintiffs who fall in exactly the same category. It was really a rather remarkable group of people who really love eagles and go out and have spent a lot of time not only looking for eagles and looking at eagles, but also engaging in all kinds of activities aimed at conserving eagles, monitoring for them, sharing information with others, participating in, eagle counts and bird counts. And so these are people who really had a very impressive, and I think impressive to the court, background in very tangible activities and could therefore assert very concrete interests of their own in eagle conservation. And then the organizational plaintiff that we had is a group called the American Bird Conservancy, which is one of the leading groups specifically oriented towards conserving migratory birds, including eagles, but not limited to eagles, but it has also been very involved in this whole issue of how do we build wind power in a way which balances the need to protect eagles and other birds. And they actually have a whole project called the Bird Safe Wind Campaign, which is designed to do exactly that. How do we develop wind power while also minimizing impacts on migratory birds? And the judge basically found standing based upon the interests of these individuals. And it was actually a very helpful ruling because one of the issues that's come up frequently is how do we go after broad programmatic changes while having standing by people who can assert injuries from that even before the regulation has been put into effect. And one of the things that people may be interested in, because it comes up a lot, here we couldn't yet challenge a particular permit that hadn't been issued because the rule hadn't been in effect long enough. So we brought what we refer to in the law as a facial challenge to the regulation, not as an applied challenge because we didn't have an applied situation yet. But we argued that the rule itself was sufficiently injurious to the interests of these individuals as well as members of the American Bird Conservancy because the entire purpose of the rule was to facilitate and encourage the construction of wind power projects in eagle habitat throughout the country. That's the entire purpose of you wouldn't need the rule if you didn't plan on building, your project at a place where the eagle populations might be affected. So our argument was that this really posed a very serious threat to the interests of these individuals, eagle lovers, as well as others. And the court ultimately agreed that that was a sufficiently tangible, concrete injury to allow us to bring this facial challenge to the regulation and have Article 3 standing to do so.
It's so much easier to establish standing in environmental cases, of course, but that shows that it's not, you really still have to always find the right plaintiffs, but you clearly did here. So let's get back to the court's decision. Can you just summarize the court's decision for us about why the NEPA, let's focus on the NEPA cause of action since that's the one you won. And why
we always like to focus on the ones we won instead of the other ones.
Why did the court find that that they did not comply, that they had to comply with NEPA and their excuses for not complying with it were not good enough?
So basically, the court ruled that the invocation of a categorical exclusion here, which was their justification for not doing any real NEPA compliance, was arbitrary, capricious, and unreasonable for two reasons. One is that the categorical exclusion that they invoked on its face didn't make any sense. And then secondly, even if you could fall within the plain terms of that, one of these, what I referred to before, extraordinary circumstances would come into play that would prohibit the use of an exclusion under these circumstances in any event. So on the first point, she said that the categorical exclusion they tried to invoke, which was for administrative actions for the most part, that in and of themselves would have no environmental impact, just could not be used here at all because, as the judge put it, even though there might be an administrative component to this, any permitting scheme could sort of be described as administrative. the entire purpose of this regulatory change was to have a very serious substantive impact that went way beyond simply an administrative effect.
That seems like an exception that would just completely swallow the rule. I mean, everything's administrative. It's an administrative agency. Everything they do is administrative in some way. So if they could argue that this was merely administrative when it has such a huge substantive impact, that seems like a pathetic argument for them.
Yeah, well, I agree. And the whole thing just always seemed very counterintuitive to us. And I think you've sort of put your finger precisely on what really is kind of an underlying important dimension to this, which is, you can see on some level it makes sense for agencies to have category exclusions so they don't have to do NEPA compliance on every single little thing they do. But on the other hand, if you're not applying those exclusions in a common sense way, then as you've just, I think, very correctly pointed out, the exclusions wind up basically swallowing the entire purpose of NEPA review. And I think the sort of judge got this, that, if you want to bandy about words like administrative, maybe there's some very technical things that agencies do which really are, very minimal. And if you define administrative in a very narrow way for personnel changes, or as I said before, procuring pencils or things of that nature, which really don't have any relationship to the environment, that's one thing. But if you start to use a word like administrative to encompass a rule change, which is designed to encourage an entire industry to build projects in places where eagles have to exist, the net becomes not only an unreasonable, I think the judge was being charitable to them in characterizing it that way, it becomes an absolutely absurd use of a category exclusion to avoid taking the hard look that NEPA requires. And so, I agree with you completely, and I think my sense is that the judge, although I think she was showing a fair amount of restraint, just sort of regarded that as a very counterintuitive invocation of an exception from NEPA review. And so that, I think, was sort of the first basis on which she rejected their argument. And that would have been enough because, to invoke one of the exclusions, you have to find that it falls within the four corners of one of the exclusions. But she didn't stop there. She actually went to the second step and said, even if you could characterize this somehow as administrative or falling within that kind of category, it still doesn't make any sense, because I find that one of these extraordinary circumstances would come into play under which you can never invoke a category exclusion. And the one she focused on was a extraordinary circumstance for when you have a quote-unquote highly controversial agency action. And so under the CQ regulations I mentioned, as well as the Fish and Wildlife's own regulations, if you have a very highly controversial action, even if you could otherwise invoke an exclusion, you could never do so when you have something which falls in that category. And she said, in effect, this is the quintessential highly controversial action. You have not only all these conservation groups, and American Bird Conservancy, Humane Society, Defenders of Wildlife, many organizations were strenuously opposed to this, as well as a number of Indian tribes and tribal representatives, as well as scientific groups, but also, and she just really highlighted this, some really remarkable opposition within the Fish and Wildlife Service itself. We had the author of the rule describing this whole process as a train wreck, doing this without NEPA review. We had another person who was involved in the rules development calling it a no-brainer that you had to do NEPA review. That was the Fish and Wildlife Service person's word. And the judge went out of her way to highlight this opposition within the agency itself, all of which went to the Fish and Wildlife Service director, who nonetheless pressed forward with no NEPA review. And the judge, in effect, said, when you have this level of opposition within your own agency, it's obviously a controversial regulation, and for that reason, it also requires NEPA review. So I think the judge was really struck by how vehement the opposition was, not only outside the agency, but also within the agency itself. And I think that made it a pretty easy call for the judge to say, this is certainly a controversial regulation that at least requires, some level of NEPA review. And pretty clearly in EIS, I think the judge sort of implies in the course of her ruling, not necessarily point blank requiring them in EIS, but saying, this certainly seems to require that level of NEPA compliance. So that was really, I think, the upshot of the judge's ruling, both on the applicability of the exclusion on its face, as well as this extraordinary circumstance that would come into play even if you could otherwise invoke the regulation.
So it's just so interesting that within Fish and Wildlife there was so much disagreement about this. And going back to the things you were saying at the beginning about climate change and about wind power, and if it was a different industry, if it was oil or coal, you would think, oh, they have such influence on the agency. Is there now such a thing as big wind that's having an effect on federal agencies, or is this really a conflict of are people really conflicted on good environmental impulses on how much they should be encouraging wind power as opposed to how much they should be worrying about the effects of wind power? What is the power of big wind within the federal government?
Well, it's huge. There is big wind, and these are not mom and pop operations for the most part. Did I
name it, or is it actually called big wind?
No, people actually refer to it as big wind.
Oh, I had hoped I coined that.
And a lot of these wind companies now are either owned or subsidiaries in various respects of the major oil and coal companies. So we no longer we have wind operations that are now owned by BP, Mobil, Exxon. And that brings with it all that you might imagine, major corporate power would bring with it. And that doesn't necessarily, again, mean that wind is bad, but it does mean that you have extensive, heavy lobbying being done so that they can build their projects in as expedient and as least costly a manner as possible. And so there absolutely is big wind, and it's very forceful. And I think it actually touches on the other thing you mentioned, too, which is why this becomes so complicated. At the same time that we have, obviously, that lobbying pressure, it is something which has been very difficult. People care about environmental values and care about wildlife because it is undoubtedly the case that a shift to renewable energy in some way, shape, or form is tremendously important for wildlife, throughout not only the United States but the world. So it's been a difficult issue, I think, in many ways for a lot of conservation groups and others to come to grips with. Exactly where do we draw the line? And having worked on these issues for many years myself, I think there has been something of a sea change out there where initially it was very hard to get people to think seriously about wildlife impacts of not only wind power. This is true about other major sources of renewable energy too. People know about this, but some of the huge industrial solar projects are having huge wildlife effects, including on birds. A lot of the birds fly over some of the major solar projects which are out there that are being put in the desert in the West, and the birds confuse those places for lakes and other sources of water, and many birds have basically crashed into many of the solar panels that have been put up if they don't take appropriate precautions. So a lot of people have for a long time been sort of warning, let's not make the same mistake as we transition to renewable energy, that we just avoid even considering these impacts until it's too late and then look back and say we wound up killing millions of animals when it could have been avoided if we had incorporated some precautionary measures at the outset. And it's been a very difficult, I think, issue for, I think, a lot of groups to kind of come to grips with, but increasingly they have. And I think that there have been efforts, more recently, not only by sort of, folks sort of crying in the wilderness, but by some of the major organizations that otherwise, would want to promote renewable energy, saying we really need to do that in a way which takes into account, impacts on migratory birds as well as bats, as well as other species that are affected when you build these things in places they don't belong and without, adopting measures designed to minimize and mitigate those effects.
Can you do it right? I mean, is it possible to site these wind turbines without harming? I don't suppose it's possible to do it without harming any animals, but without unduly harming animals. I don't know how to put it exactly, but is there a good way to do it?
It's a great question, and I think it's something people are still struggling with. And the answer is there are certainly ways to do it that avoid unnecessary and extreme effects that otherwise would occur. Even things like what are called micrositing, where you could basically have a project where if you basically go up onto a mountain that you want to build a project and you do effective monitoring and studies for a number of years in advance, you basically learn that if you build a project in a certain place, you will be right smack dab in the middle of the migratory route. But if you shift it even a couple of miles away or even a half a mile away, you could really reduce the impact tremendously. And so a lot of people have been pushing for having those kinds of pre-construction surveys done. And of course, the industry frequently pushes back on that in order to avoid the cost of that. And one thing I should say is that this is not a monolithic